Thank you, everybody, for joining us today for Hinshaw's Labor and Employment Regional Law Update for the West Coast. And now it's my pleasure to introduce today's presenter, Bill Bogdan and Melissa Schaefer. Bill Bogdan, a partner in our San Francisco office, focuses his practice on construction issues and employment litigation and counseling. He frequently represents contractors in indemnity, injury, and property damage actions, and employers in a variety of workplace and compensation disputes. Melissa Schaefer, a partner in our Los Angeles office, represents her clients in labor and employment matters in addition to workplace injury litigation. She defends employers facing a wide range of employment disputes, which includes extensive experience with matters involving discrimination, harassment, retaliation, wrongful termination, and wage and hour violations.
Thank you, Stephanie. If we could move to the next slide. So we are moving forward today with what we are considering the West Coast, the California update on labor and employment laws for 2024. As all of you likely know, California is a hotbed of new laws every year, and employers are always kept on their toes in trying to stay on top of them and make sure that they are as compliant as they can be with all of the new laws. So Bill and I are going to touch on the main laws that have come out this year, as well as some new cases that have come down that likely will affect you in your business. So we will be going through everything one by one. If you have questions, please feel free to put them in the chat. If we do have time at the end, we will go through some questions. If not, we will get back to you after the webinar is over. So starting off today, we thought minimum wage would be a great place to start. As you know, or likely know, usual minimum wage is about $15. California has always been a little bit different, and as of January 1st of 2024, we have increased as a state to $16. Now, cities and counties around the state of California do have different minimum wage rates depending on where the employer might be located. I've put down in the slides a couple, just because we have Los Angeles and San Francisco on today's webinar. Los Angeles is $16.78 and San Francisco is $18.07. The DIR website does have a great chart for various cities if you want to check your individual city of where you have locations to make sure that you are compliant with the new minimum wage laws. In reference to the salary exemption test, this has slightly increased from $64,480 to $66,560. And as you'll note from the slide, if you do have a collective bargaining agreement, there's a slight change in that one. Next slide, please. The main issue that has come across for 2024 is that of healthcare workers. Those of you who pay attention to this might have realized and saw during 2023 that there were some things that were going through the pipeline in reference to increasing that in various cities, Los Angeles being one. And this stemmed the law that has passed of SB 525 that's effective as of June 1st of 2024. Now, it is a very convoluted new law statute that requires a lot of detail. Now, if we can move for this one, if you look at the slide, a covered healthcare employee, what does it entail? There's a long laundry list. I don't need to go through all of them, but as you can see, there are many qualifications that list in this. And you should also note that this list can also include contracted and subcontracted employees. Now, what this does not cover is anybody doing outside sales work performed in a public sector, where the prevalent duties are not healthcare services, delivery or waste collection of a covered healthcare facility, or medical transportation. Next slide, please. So what is a covered healthcare facility? That means that you are entitled to, required to adhere to this new law. You can see a long list of these as well without me having to go into each one of them. You can look at this list to see if you are required to do this. In addition, the exemptions are a hospital that is owned, controlled, or operated by the State Department, or a tribal clinic. They will not be included in any of these definitions. Now, if we could move to the next slide. This is where the tiered system applies and controls in reference to what you need to do and what year you need to do it. If you look through the 4 different the 5 classifications, they range from $24 an hour or so in increase. They also go up from when it starts in June of 2024 through May of 25, an increase each year. And it goes through June of 2026 for some and till 2027 for others. So what is really important is to go through each one of these to find out what one you fall under and figure out what your requirements are. Now, there are some exceptions or caveats if we can move to the next slide. First and foremost is that any healthcare facility that is county owned, affiliated, or operated are the ones that have to comply with this, but only by January 1st of 2025. So they get a 6-month reprieve in comparison to other people who qualify to adhere to this new law. In addition, there's a salary basis test. And in this case, the employee must earn a monthly salary equivalent of no less than 150% of the healthcare worker's minimum wage or 200% of the applicable minimum wage, whichever is greater, for full-time employment in order to qualify as exempt. There is also a waiver program, and this allows a covered healthcare facility, so one that technically applies and needs to adhere to this new law. It allows them to apply for and possibly receive a temporary pause or an alternative phase in the schedule for the minimum wage requirements detailed in the previous slides. Now, this process is going to be developed by March 1st of 2024. So at that point, that is when a required healthcare facility would be allowed to seek this waiver. Now, in order to obtain the waiver, any such healthcare facilities must demonstrate that compliance with the minimum wage requirements would raise doubts about that healthcare facility's ability to continue as a going concern. This is going to be solely within the discretion of the Department of Industrial Relations, and determining whether an entity demonstrates the inability to continue as a going concern is solely and exclusively within the authority of the State Department of Healthcare Services. Next slide, please. And I'll pass this off to Bill.
Thanks, Melissa. My apologies for the headset, but we found out that the audio was a lot better with it. It brings me back to my days when I was a directory assistance operator for the telephone company. So in addition to questions, if you need the number for McDonald's and want to give me the address in the chat, I can look that up for you. So California has expanded their paid sick leave. We already had a law that required that employees receive 24 hours or 3 days off for illness and get paid for it. There were 2 ways that you could set that up. You could either front load your employees every year, where they got to use the time immediately. The exception there was for new employees, they weren't allowed to use the sick time until 120 days had passed. Or you would use the accrual method, which meant you would get 1 hour paid sick leave for every 30 hours worked. And if you do the math, you'll realize that if you do that over the course of a year, you're going to wind up with more than 24 hours or 3 days worth of sick leave. So they put a cap on the accrual at 6 days or 48 hours. We see on the next slide, the new law provides you get 40 hours or 5 days. I don't know if the legislature decided that people were getting sicker than they were and needed more time, but they have decided to increase the amount of time available. Again, we're going to have the front load system or the accrual system. But with the accrual system now, not only do you get an hour for every 30 hours worked, but by your 120th day of work, you must accrue 24 hours. And by your 200th day of work, you must accrue 40 hours of paid sick time. So there's 260 work days in a year. If you do the math, that's an extra 16 hours or 2 days worth of sick time beyond what the legislature requires. So they've capped the accrual at 10 days or 80 hours, And you can limit the leave taken in any 1 year, though, to 40 years or 5 days, which means people get to bank a lot of that time. As we see on the next slide, the law now applies to people who are operating under a collective bargaining agreement if they are outside the construction industry. Apparently, under union contracts, people on occasion were required to find a replacement worker if they were going to take sick leave, which in effect was a denial of the ability to use the sick leave. So that has been wiped out by the new law. Also, as a reminder, you can't condition the paid sick leave on medical certification, but you do have the right to ask. If you're getting information that people aren't using sick leave for the proper purpose, for example, you see on Facebook that they're in Hawaii rather than a hospital, you have the right to ask for certification to justify the sick leave. Melissa?
Thanks, Bill. Moving on to the next new law that is, I think, one of the more difficult ones for employers to comply with is the Workplace Violence Prevention Plan Act, SB 553. Now, California is the first state to implement such a law, and basically it is applicable to all industries with the exception of some healthcare facilities because healthcare already has their own laws that apply to them in reference to what they need to do. So as I mentioned, this is effective as of July 1st, 2024. And as we move to the next slide, you will see what kind of things you need to do. Now, in creating your workplace violence prevention plan, there are two ways to do it. One, you can create it on its own, so have it your own workplace violence prevention plan in and of itself. Or two, you can add it or include it in your already completed injury and illness prevention program. So you do have that option and what to do. But if you look at the slide we're looking at right now, you will see the requirements are quite lengthy. There are a lot of things that employers need to utilize and comply with and do in order to be compliant with this. The other thing that I think is quite taxing for the employers is this is a never-ending process. So you'll see on the first bullet point, it says identification of the person or persons responsible for implementing the program, including names and job titles. This is something that is ongoing. So whomever you choose to do this or the group of people you choose, it's constant. Because what happens is anytime a new threat of any kind is identified, everything that you're looking on these slides has to be evaluated again, and you need to add to the workplace violence prevention plan. So it is something that will never be, once you complete it, you put it aside and it's in the binder and you pass it out and you do all that. That will not be sufficient if you learn of new hazards or threats. So keep in mind that this is something ongoing. So if you are giving this job to somebody who has a packed agenda and does not have time, you're probably going to have difficulties down the road in making sure you have compliance with this program. Moving on to the next slide, you can see one of the requirements is creation of a violent incident log. Now that has its own separate requirements, and those are detailed right in this slide. One of the ones, if you look at the third bullet point, it talks about the classification who committed the violent act. What we're doing, or what the state is doing, is monitoring what kind of violent acts are happening at an employer's location and premise. So I think we can create ways to avoid it, prevent it, etc. So once you have your plan and you have your violent incident log created, you need to do all these things, and one of them is noting the classification. Now, if you go to the next slide, there are 4 different categories for classification. And they're violence by a person who has no legitimate business at that work site. There's violence directed at an employee by customers, clients, patients, etc. There's violence against an employee by a present or former employee, supervisor, or manager. And as you know, those are usually the ones that make the news. And lastly, violence committed in the workplace by a person who does not work there, but has or is known to have had a personal relationship with an employee. Those might fall under the domestic violence type of incidents that we do hear about. Now, the workplace violence will not include any lawful acts of self-defense or defense of others. So you have to remember you don't have to include that. But in addition to the violent incident log, you also need to remember that if it is required to be put on the OSHA 300 log, you still have to do that as well. Now, along with this new law comes more record keeping. So if we go to the next slide, we can learn about the record keeping requirements. Some of them make sense and others are a little bit odd. For instance, the hazard identification, evaluation, and correction records shall be maintained for 5 years. But yet the training that you're required to do only has to be maintained for 1 year. I don't think this makes a lot of sense personally, and I do recommend that you maintain your training records longer because all you would need is someone to say, well, I wasn't trained on that. And if you are disposing of those records after 1 year, you're not going to have that proof in case that issue were to come into play. The violent incident log is also 5 years. And then along with the record keeping, you should also be aware that the division can request them. But I think the more important thing to note is that the training records, violent incident logs, they need to be made available to employees and their representatives if they request it at no cost to those people within 15 days of the request, and this 15 calendar days. Next slide. Now, the training requirements, we won't go through all of them, but you can see that these are the list of things that you have to do in reference to training all your employees. And this is what you'll need to maintain for a minimum of 1 year. Again, I recommend more than that, but that is your minimum requirement. Failing to keep those records, of course, could end up with difficulties later on. And with that, I'm going to pass it back to Bill to talk about our next new law.
So for you conspiracy theory people out there, the legalization of marijuana hasn't been the financial boom that governments expected in regards to earning tax revenue. So while we have laws now that prevent you from discriminating against people who use cannabis out of work, it almost seems like they are encouraging the use. We are to the point where use of marijuana has now been promoted through the Fair Employment and Housing Act, FEHA, to be a subject akin to sex harassment, sex discrimination, racial discrimination, because they don't want people punished for using it. We have actually two laws. One is enacted in 2023 and just became applicable last week. The other was in 2022, but had a delayed start date. So the one that was in 2022 just went into effect January 1st this year, and it provides FEHA protection for recreational users of marijuana. So now it is unlawful for you to discriminate for use of marijuana that you determine the employee has been participating in if it is off the job or away from the workplace. You are also prohibited from testing what are called non-psychoactive metabolites. So the psychoactive element of marijuana is THC, and if that is detected, it shows that you're presently impaired. But if it's non-psychoactive, you could have smoked pot 3 weeks ago, and that would still be in your body. And that's what the law is prohibiting you from disciplining people for. So you can still test for marijuana, but it has to be some sort of bodily fluid or saliva test. It can't be testing for these non-psychoactive components. In the next slide, we see that this law does not apply to the building and construction industry. Makes sense. It's a very safety-oriented industry, and you don't even want the possibility of trace elements somehow affecting performance. It's also inapplicable to industries requiring a federal background or clearance checks because federal law still prohibits the use of marijuana. But it applies to everything else. Transportation, people driving trains, you would think that would be a concern. No. Healthcare, it applies. Manufacturing, agriculture, the only industries excluded are building and the construction industry. Now, you're still allowed to prohibit people from using or possessing drugs, and you can maintain a drug-free workplace. If somebody's impaired, you still have the ability to terminate them, and you still have the ability to test after an accident or if there's a reasonable suspicion. But the caveat there is you have to make sure that you test that person before they go home from the shift. Because if they go home and you test them the next day, you're not going to get the readings for the person's condition at the time that the accident occurred. The third law on the next slide, second law, is that in job interviews now, you can't ask about prior marijuana use, just like you can't ask about prior prescription drug or alcohol use. You can't use criminal convictions in relation to cannabis possession as a reason to refuse somebody employment. If you have the ability to give a pre-employment drug test, again, you have to test for the psychoactive metabolites, not the non-psychoactive. And as I said, having raised this to the level of protection under the Fair Employment and Housing Act, violation now earns the employee attorney's fees if they prevail on the claim. Melissa?
Thanks, Bill. You actually noted one thing that I want to expand upon real quick about testing after an accident or reasonable suspicion. In workplace injuries, please always remember that some people have for years have had policies that after every accident, a drug test was done. The reasonable suspicion is more prevalent now in reference to workplace injury. If you test on something that really has no play in reference to drug use or alcohol abuse or anything like that, you could be have an employment action brought against you for wrongfully testing. So you want to make sure that you do have a reasonable suspicion if you do have a workplace injury as to why you're doing a drug test after an accident, just to make sure that you stay as safe as you can in reference to that. Now, moving on to arbitration stays. So arbitration has been a big thing in the state of California for years, and we'll talk a little bit about it later on. But arbitration agreements are something that employers have tried to use for years because it does save costs. It's very cost effective, and it keeps you away from a jury. A jury, as you know, can be very sympathetic and can really hit an employer hard in reference to an employment case. Now, with arbitration, normally what would happen is you have your arbitration agreement, you submit it, and you're telling the other side that you want arbitration. And if the sides don't agree, obviously the motion is put before the court to see if your arbitration agreement is valid and whether you are entitled to arbitration. No matter what happens in the outcome, one party is going to be upset. Plaintiff if they are told they have to go to arbitration, or defendant if they're told they don't get to go to arbitration. So then they appeal. What this new law says is that when an appeal to arbitration decision, whether it's for arbitration or against arbitration, when that appeal is going forward, it used to have an automatic stay on the trial court proceedings, which makes sense, right? If you're going to move into arbitration at some point down the road, why would you want to recreate the wheel twice? And of course, that incurs additional litigation costs for the employer. Well, with the new law, as of January 1st of this year, there is no more automatic stay when either party files this appeal. Now it is up to the trial court on whether the trial court proceedings continue. What I found the most interesting is this is completely opposite of the Supreme Court case. In 2023, that they held that it must stay any pretrial and trial proceedings while an appeal is pending. Now, again, as we've seen throughout the arbitration cases that have been coming down the pipeline over the last few years, they're all being challenged under the Federal Arbitration Act. So in that regards, we're anticipating challenges for this currently for 2024. I have not seen anything yet, but again, what is today's date? January 10th. The year just started. But if you do have this action, you might be forced to litigate in the trial court while you are appealing your decision to go to arbitration. And this could incur additional costs. Next slide. Moving on to reproductive leave. So this is a new leave of absence that has come out as of January 1st of 2024. It applies to employers with 5 or more employees, but they have to have been employed for at least 30 days before they're entitled to take this leave. There's a few details in this new law. Specifically, what is a reproductive leave? And the law has defined a reproductive leave as a failed adoption, failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction, IVF basically. The leave is for 5 days. It is unpaid, but it does not need to be taken consecutively. So you need to remember to keep track of the various dates if someone is utilizing this. The leave in and of itself must be used within 3 months of the reproductive loss. So they can take those 5 days anytime within those 3 months. But if we move to the next slide, there is also something with regards to multiple reproductive leave losses. So at that point, if they experience more than one in a year, they can get up to 20 days within 12 months. So keep that in mind. And similar to the law that Bill talked about with regards to paid sick leave, again, they're not required to provide medical documentation to support the request. Now, you cannot force them to use any of their accrued time, PTO, sick time, vacation, but it can be made available to them if they choose to use it. So it is unpaid leave, but they could just take the days unpaid without using any of the time that they've accrued. So this is one that we are recommending that you do update your handbook accordingly or put an addendum in there just so you have this leave noted. But it is the one new leave that has come out in 2024. Bill, back to you.
So should come as no surprise, California hates non-compete agreements. And they enacted a law to say you can't have those, and everybody ran out and tried to get around them. So what we are seeing continually is the legislature updating the law to cut off those avenues to try to enforce non-competes. So if you have an agreement with a California employee and you are an out-of-state company, you are not going to be able to enforce that law against the California employee. Likewise, if you're a California employer, you're not going to be able to enforce a claim against a employee who's out of state if your employment agreement says that the law of California is going to govern the employment. What is interesting about this law is that it applies to your current and your former employees who have signed non-compete agreements. So for anybody you employed after January 1st, 2022, not only is the clause void, you have to go out and tell them it is void. You have to give them some sort of notice in an individualized manner by February 14th, 2024. So when you send your current and former employees Valentine's Day cards this year, please include in there the fact that the non-compete clause that they signed is invalid. Melissa?
Thanks, Bill. Another new law that has come down over the 2023 legislative session that's effective as of January 1st is the rebuttable presumption in retaliation per SB 497. Now, what this does is it creates a presumption in favor of an employee's claim if an employer engages in any action prohibited within 90 days of a protected activity. This would include reporting an employer's wage and hour violations, equal pay violations, etc. So what does this mean for you as the employer? Well, one, the protected activity includes any complaint about unpaid wages, any complaint about suspected unlawful activity in the workplace, and of course, the equal pay as I noted. Now, as an employer, going to the next slide, what you are able to do and not do. If for any reason this person is disciplined, terminated, any of those things within the 90 days when they reported, you could have a rebuttable presumption against you in that the action you took against this employee was related to their complaint about wage and hour violations or equal pay violations. So what you need to do is evaluate anything in reference to termination, disciplining an employee who has made one of these complaints. You want to make sure that you're looking at the 90-day time frame, and if for any reason there is any reason to delay, obviously taking any of those actions after the 90-day period will take you out of the rebuttable presumption period. So that would be a recommendation. Now, if you are found liable in this case, the civil penalty has increased from a maximum of $10,000 to $10,000 per employee per violation. So obviously it greatly increases. So obviously take check of any kind of complaint, watch the 90 days, really have your HR and management be trained on this so you don't miss anything. Moving on to the next slide with Bill.
So California had always allowed employers to obtain restraining orders in order to protect employees. And if there was an actual or threatened assault, battery, or there was an instance with stalking, that created a credible threat to either the employee or the employee's family, the employer could get a restraining order to help protect that employee. Violence or threats of violence in self-defense or in the defense of others was exempt from that. And what the government did this year was expand it so now you can get a TRO not only for assault, battery, or stalking, but for harassment. And it's not harassment in the sense that it's limited by FIHA. It's no longer tethered to protected characteristics. Harassment against anybody, even me, would be covered now if you meet the standards. So you need a knowing and willful course of conduct by the person being restrained. The activity has to be directed at a specific person. They can't just be doing something general against the employer. It needs to seriously alarm, annoy, or harass the employee. It serves no legitimate purpose. And then there's an objective and a subjective element. It would cause a reasonable person emotional distress and actually causes substantial emotional distress to the employee. There are exclusions on the next slide that if it's a situation where it involves protected speech or union organizing, it can't be subject to the restraining order. And also, if you are going to file as the employer on behalf of an employee, you have to ask the employee whether it's okay to identify the individual when the order is submitted to the court. Melissa?
Thanks, Bill. The next slide deals with food handlers and the process in which a person, an employee, gets a food handler card. Now, prior to the implementation of SB 476, an employee was required to do this on their own. The cost was not very expensive. It's about $115, but they had to go and do the training, take the examination to get their card in order to have these types of jobs. Well, what they've done now is basically transfer the liability, the cost, from the employee or the applicant to the actual employer. So, in order to get a food handler card, an employee or a candidate must complete a training course and take an examination. The good news is that the card is good for 3 years and it is transferable. So you might end up with an employee who got it somewhere else and comes over, but then while they're employed with you, they need to renew it. So you would be on the hook for the renewal. However, if you are interviewing for a new position or adding to your staff and someone applies and they don't have one, you one cannot not take this person if they're qualified because they don't have one and discriminate against them for not having one. But you would need to take the cost on and the time. Well, what this means for the employers is not only do you pay for the training course and the examination and the food card, which that part's, I think, easy. It's about $115. That's fine. But what I think is the problem and the issue that people will have with this is going to cross over into wage and hour issues because you need to pay this employee for their time that they take for training and examination. So you need to make sure you're monitoring their hours so they're properly paid so you avoid any wage and hour violations. Now, at the time that they're doing this, you also have to relieve them of all duties. So while you might think like, oh, I can use this person for 4 hours and they can do this, you can't do that. So you really have to get them in to have their food handler card, take the examination, the training course, etc., before you can have them do other work. So you basically could have an employee on the books that you're paying benefits for or something else, and you can't utilize them in reference to the position you actually hired them for. So that is an extra cost for sure to the employer. So something to monitor. And again, as I mentioned, you cannot condition employment on them having an existing food card. If they do, that's just a benefit to you. Bill?
So a lot of the COVID laws have sunset. It's not like the pandemic, or it's not like COVID's over, but the panic and the pandemic have pretty much run its course. So we had a law that said that if you laid off employees because of the stay-at-home order, uh, until December 31st, 2024, they would have a right to be rehired, given priority over hiring other people. So you had to give them the job offering in writing and email and text if you had that kind of information. If the employee wasn't recalled, you had to give written notice as to the reason within 30 days of hiring the other person. And if multiple people were laid off, you had to rehire in the order of seniority. But when you look at the next slide, the new law has now expanded the time frame because we're going to push this sunset clause out to December 31st, 2025 for any layoffs after March 4th, 2020. And it also has broadened the COVID relationship to the termination. So now we're going to presume that it is COVID related if you're laying somebody off because of a lack of business, a reduction in force, on top of public health directives, a government shutdown order, or any other economic non-disciplinary reason. And it becomes the employer's burden to justify that it's not COVID related. So let's take the example of CVS or Walgreens in San Francisco, where you have people coming in off the street and shoplifting is rampant. And finally, they decide to shut down the business. That would be seemingly a non-COVID related reason until you get creative and start trying to argue that, well, perhaps it really was the lack of business coming into the drugstore to keep up the financial health of the business. And it was because there weren't enough people in downtown San Francisco due to COVID. So it's going to be dicey. On the next slide, we have a new law regarding disclosure requirements because of wage theft, primarily in the agricultural area, because people were not being told the truth regarding COVID prevention or correct payroll information. So now, at the time that you are hiring an employee, there is a slew of things you have to now disclose, but the new element is that the employee must be informed of any government or emergency disaster declarations issued within 30 days of employment that could affect the employee health and safety. Also, in the old days, you'd have to have a class action to get a lawyer interested in trying to enforce these laws, because that's the only way you're going to make money. Now, enforcement's been expanded so that any public prosecutor within a geographic area can pursue a civil or a criminal claim. So any district attorney, city attorney, county council can file an action. So that does two things. One, it is a revenue source now for the government, because once the employee is paid off, any penalties go to the government. And two, the government, you might have read, has a lot of resources, and they aren't profit driven. So they'll take on claims that they aren't going to necessarily make money on, yet they've got the taxpayers bankrolling the litigation. So you'll find that government will pursue claims that the private sector would not. Melissa?
Thanks, Bill. I did get one question regarding the food handler that I want to just quickly address. The question was, could you make it a requirement for your job posting that a card is required? I would advise against that because the law clearly states that you cannot condition employment on an applicant to have a card or an employee. So I don't think that would be a safe bet. I mean, as I always say, you can do anything you want, but if you get caught, are you willing to take the penalty or the action? So you can judge that on your own, but it would not be recommended in reference to doing so. Now, going to the current slide, we're going to move into some cases that have come out during 2023 that have been good and bad for employers. This one actually makes me very excited to talk about because very rare do we have such a great win for an employer. This does deal with staffing agencies, companies, and employers, but it is a big win. And what ended up happening in this one is the plaintiff was hired by a staffing agency and was sent out on a job assignment and wasn't doing their job allegedly well. I believe it was verbally abusive on the phone was the note in the case. And that assignment ended. I'm sure that they did not want to keep that person employed because of the actions. So her assignment ended, but she was still valid and allowed to have other assignments with the staffing agency. Well, she claimed she was terminated, so she filed a suit for a variety of claims. And the staffing company won on motions on all of them, except for PAGA penalties for failure to timely pay final wages. And what they were arguing was that at the time her assignment ended, she should have been paid her final wages. What the staffing agency did is just paid her on the normal schedule that they'd been paying. If it was a weekly or a biweekly, whatever it was, they just paid her out in full when the next pay period ended because those were her last hours worked. And so what ended up happening in this case as it went to the courts is that they deemed that the discharge required the ending of the employment relationship. And her employment relationship with the staffing company did not end. It was a work assignment. So that did not equal discharge. So they did not need to pay her immediately. So the staffing company won on this case. So again, a very good case for staffing agencies. And if you are one of those, keep this in mind in reference to sending out any termination paperwork. Assignment ending and termination are two different words. So you want to make sure you're using the one that's best appropriate for you at that time. Bill?
So you may have read about the take-home COVID case Cusiemba versus Victory Woodworks, where a construction worker swore the only place on the planet he could have gotten COVID was at the job site in San Francisco, and his wife in Antioch swore that the only place on the planet she could have gotten COVID was from her husband. And so she sued her husband's employer for not protecting her from COVID. Uh, there were three main issues in the case. The first was it barred by the exclusive remedy doctrine in workers' comp through the derivative injury theory? In workers' comp, if you observe your spouse getting hurt on the job, you can't recover on a civil claim. That is covered by the derivative injury doctrine, where the sole remedy is the employee's recovery for the injury, not the spouse's experience of emotional distress. So in the Cusiemba case, the trial court said, yes, it is barred. And then we had another case in Southern California where the California Court of Appeals said, no, that makes no sense. The person has an independent injury that's unrelated to the employee's injury, because in theory, they could bring the virus home and the employee might not be sick, but the spouse could get sick. California Supreme Court decided that the derivative injury doctrine does not preempt the civil claim. And so workers' comp exclusive remedy wouldn't apply. So when we go on to the second issue, does the employer owe a duty to the household at all? And in Cusiemba, the district court said, no, there's no duty owed. The See's Candy case, it wasn't raised. So they just made the recommendation that somebody should decide that issue someday. Well, the California Supreme Court decided it and said that based on traditional foreseeability, yeah, there's a duty. It's foreseeable that if you don't take the steps that you need to take to protect employees, those employees are going to go home. They live with other people. Those other people are going to catch COVID. So then we went on to issue number 3, which was, does the burden to the public by allowing such a cause of action outweigh the benefit of letting individuals recover for their harm? And for the first time, the California Supreme Court said, yes, the burden is too great. Even though the harm's foreseeable, you had essential businesses that had to stay open who might not be able to stay open if they had to deal with litigation. There was the potential that those essential services they provide would be curtailed, and that the courts would be overwhelmed with cases because there was potentially infinite number of people who could file, but they could never really prove the claim. So they were afraid with the courts being clogged with all these cases. The plaintiff tried to argue that this was like asbestos, where you do have liability for a take-home claim, but the Supreme Court said this is something different. Asbestos is a product that you use to make money. Nobody's making money over COVID, and you can't trace any particular infection back to the employer. So on the next slide, we see that there still is an outstanding question where, what do you do with people with disabilities? And there's a case pending right now in Southern California where they say that you knew or should have known that the person's medical condition made them more susceptible to COVID, and you should have done something extra to protect those people, and you didn't engage in the interactive process to protect them. So that's one issue that's still out there. And then just today, the Ninth Circuit certified a question to the California Supreme Court on the duty owed by Uber to protect riders who are injured by somebody who has been suspended as a driver. They had somebody with a history of assaults that they suspended, and then the guy went out and still was picking up passengers, not through the Uber app, but through deceit. And so the question is, what duty does Uber have to third parties? We're going to see Kusiemba all over that opinion, I think. Melissa?
Great work on that case, Bill. We're going to move a little bit quicker for the next few cases to make sure we can try to end timely at 1 o'clock. The next case deals with whistleblower protection. And just to give you a little bit of background on this one, the employer, to me, did not act in the best interest of the employer in this case. It started off with a DLSE action, and they were told and recommended, the employer was, to pay wages, reinstate the job, and pay some civil penalties. And they refused, and thus this case ensued. And what ended up happening is this employee was a bartender who claimed some unpaid wages. And then after she made the claim, she was terminated and threatened on her immigration status. And so it was all just very bad facts. So the trial court ends up dismissing this 1102.5 whistleblower action because the plaintiff lodged her complaint about wages to the employer, not to a governmental agency. So on appeal, they upheld the trial court decision, noting that disclose meant something new, or at least believed to be new. But because the employer already knew what she was claiming, this did not amount to whistleblowing. So then it moved up to the Supreme Court. And as you'll note, they noted and held that a report of unlawful activities made to an employer that already knew about the violation is still a protected disclosure. It did not have to be new or believed to be new. And then it also noted that the disclosure has to be made to a person with authority. And since she had reported it to her employer, her boss, her manager, this was met. And then it also finally held that the disclosure meant that an employee's report or complaint that calls attention to any legal violation or potential violation would be a disclosure. So this would be a new whistleblower case to pay attention to. Moving on to the next case. We have another discharge case with the Harstein case. This started off in COVID when all the hotels were laying off people. Basically, what it holds is that an indefinite furlough does equate to a termination and the proper time to pay any accrued time. In this case, they sent out a letter in March when the COVID shutdown hit, saying that they were furloughed and they couldn't give a return to work time frame. They sent out a second letter in June of 2020 when COVID was still continuing, noting that this furlough was now going to be a termination and they'd be paid anything that was outstanding. What I think is important to note that Hyatt actually did let them know in the first letter that they could ask for any accrued vacation time payout at that time. So they did give the employee the opportunity to do so, but Hyatt didn't do it on their own. And the end result was that they should have paid it at the time they did the indefinite furlough in March and not in June when they decided that they could not bring people back. So that is what the Ninth Circuit held. So something to just be aware of when you're doing an indefinite furlough. Who knows what will happen in the future if this issue will ever come up again, but this case does exist. Bill?
Thanks, Melissa. So I've got 4 minutes to cover 4 cases, and it can be done. So first case concerns remote work. During the shutdown, IBM had its employees work at home, and the employees said, well, to work at home costs money, and I got to pay for internet, and I got to pay for my phone, and that's something you should be taking care of. IBM said, well, you're already paying for your internet and you're already paying for your phone. And we didn't cause you to work at home. It's the government that shut down our business. And so we didn't cause you to incur that expense. And we see on the next side, the result, the court said the statute doesn't talk about cause. There's no proximate cause element involved. If the expenses are due to the performance of the employee's duties, the employer pays. So these things were inherent in IBM's business. The work was performed for the benefit of IBM, and it wasn't a situation like masks where it was a personal item that you could use anywhere. This was things that were, while being used for work, were dedicated to work. The next case is regarding PAGA arbitration, Adolf versus Uber Technologies. The 12-second history of PAGA is California Supreme Court likes it, U.S. Supreme Court doesn't, and U.S. Supreme Court wants to be able to push those into arbitration. But in Viking River, the Supreme Court said that you can force a PAGA claim if it belongs to an individual to go to arbitration, but you can't force that person's ability to pursue PAGA violations for other people in arbitration. So going to the next slide, in the Adolf case, if the individual has to go to arbitration, does he still have standing to litigate the PAGA claims of other employees? And what the court decided was the employee isn't compelled to arbitrate the claims of other employees. They get to pursue them in court. All that is required for the individual to have standing to represent the other employees is that that employee is an aggrieved employee. That person suffered an unlawful practice, even though he didn't personally experience every single one of the violations that others experience. So what you wind up with is a situation where, as to the violation to the person, that gets arbitrated. As to violations to others, it goes to court. Potentially, you got two things going on at the same time. So what are courts doing with this? Courts are overwhelmingly requiring now that the individual claim, that gets arbitrated first, and they're going to stay the action on the other claims. Why do they do it that way? Because if the individual arbitrates and loses, they're not an aggrieved employee. They don't have the standing because they didn't suffer an unlawful practice. Moving on to PAGA, usually you get coming attractions at the beginning of the movie. Here you're getting coming attractions at the end of the movie. This is a case that has already been argued before the California Supreme Court, but hasn't been decided yet. It was just argued on November 8th. The trial judge was faced with 300 employees disputing an on-site meal period, and the court decided that that claim was too unreasonable. It was unmanageable. It couldn't possibly be tried in that courtroom, and it was dismissed. Court of Appeals reversed it. So now the California Supreme Court, within the next 30 days, is going to issue an opinion on whether a trial court has the inherent authority to strike or not narrow PAGA claims to ensure that the claims would be manageable at trial. We talked about Cusiemba earlier and the burden on the courts. That's going to come back in that case as well. Finally, ending with some good news, this is a trial court decision guaranteed to be appealed, where I got to hand it to the defense attorneys. They came up with a brilliant idea where they won a seating case, a PAGA seating case, and wanted to get their costs. Of course, the individual employee doesn't have any money. So what they decided was they were going to go after the LWDA, which is what supervises PAGA claims. PAGA claims that aren't individualized are handled by deputized employees for the state. So it really is a state action. They went after the LWDA and got $125,000 back on grounds that, hey, the Labor Workforce Development Agency has made $375 million in the last 3 years on PAGA penalties. It's being enforced, or it's being pursued on the LWDA's behalf. Therefore, we get our costs back from the LWDA. And that's what happened.
Thanks, Bill. We're just a few minutes over, and I just wanted to let you know that if you have any questions, please reach out to Bill and I individually. In addition, when you do get your slide presentation, you'll see the next slide. It's the the federal updates. We did include them in the slides knowing that we weren't going to be talking about them today, but we thought you would just like to see them. So you will get these slides in your materials just as extra because this was California based, but we thought we'll keep you updated on the federal law as well. So we really thank you for attending today.